Hello and welcome to Law 2024 Online, Commercial Property Spring, Shape the Debate with Mark Shelton, that's me, and Richard Snape. And today's Q&A is due to last 1 hour and will cover your pre-submitted questions. The recording of today's session will be sent out by email within the next few days, so please keep an eye out for that. Now, this session is sponsored by Watchman Insurance, and Watchman, as you may well know, is a specialist insurance policy only available to solicitors. It provides insurance for unoccupied properties. It's been revolutionary in changing the way probate solicitors protect their clients' estates by reducing initial pressure on your funds while you're still trying to access the estate and sell the property. Watchman achieves this as solicitors don't have to pay a full upfront premium. Covers secured by simply paying a small deposit and then continues with a daily premium charge that's deferred until the property is sold or transferred for up to a year. No finance agreements and no cancellation charges. And it's also available for homes where clients are in care or with reduced legal capacity. Getting you started and arranging covers easy. If you'd like to learn more about Watchman, you can contact their helpful team. The phone number, be quick and note it down, is 01935 389 812, or their email is watchman@practiceenterprise.com. So, brief word of introduction. I'll blow my own trumpet first. I've worked in major commercial law firms for 29 years. As a property litigator, I've acted for a range of clients from FTSE 100 investment companies and major corporate occupiers through to small businesses and individuals. I'm an expert in commercial property management law, and as well as advising on the structuring and documentation of transactions, I've conducted a wide range of commercial property disputes, acting both for landlords and for tenants. I'm now a non-practicing solicitor, and I work as a commercial property management law trainer, putting that experience and expertise, I hope, to good use in training both lawyers and surveyors. And as part of Law 2024 Online Commercial Property, my sessions include forfeiture of leases for non-payment of rent, 10 key issues, and opposed lease renewals, pushing at an open door. So that's me. Richard Snape has been the head of professional support at Davitt Jones Bold since 2002, and he speaks at numerous courses for law societies all over the country, various public courses, in-house seminars within solicitors' firms, and has also talked extensively to local authorities and central government bodies. His areas of specialism include both commercial and residential property, in particular in relation to local government law, conveyancing issues, development land, commercial property, and encumbrances in relation to land. And as part of Law 2024 Online, Richard Snape's sessions include repairs, service charges and building safety in commercial leases, and also how to respond to CPSE enquiries. Now, before we get on to the pre-submitted questions, there's something that Richard would like to add about one of his sessions, I think.
Yeah, it's the how to respond to CPSE inquiries. There's a bit about Japanese knotweed, a page and a bit about it, because there's obviously CPSE inquiries, both 1 and 7s, about Japanese knotweed, and also residential inquiries. I've always thought it was going to be the kind of things that should be surveyors' jobs, but not lawyers' jobs. And I have to say, before we start, Mark, it's nice to see the CPSE ones are considerably shorter than the residential inquiries nowadays. But there's a case mentioned, Davis and Bridgend County Borough Council in the knotweed section. And it does say it was a Court of Appeal decision from last year, and it does say at the end it's being heard by the Supreme Court. It was actually heard by the Supreme Court on February the 27th, but we only got the judgment on May the 8th, 2 days from today. And the Supreme Court reversed the Court of Appeal decision, which I thought they would. It was all about residual loss for the fact that there's Japanese knotweed at some stage in the past in this premises in South Wales. It had spread from local authority land. It was a cycle path the local authority owned. The Court of Appeal said you can claim for residual loss even if the Japanese knotweed's been treated. Could be still, there'd still be liability. The fact that you've had Japanese knotweed in the past would reduce the value of the property forevermore. The knotweed had been there since, well, no one's quite sure, but before the Davis bought the property in 2004, court decided that by 2013, the local authority should have realised the problem with knotweed but didn't treat it until 2018. The Supreme Court said you might have, been technically in the wrong as a local authority, but there was no loss as a consequence. It predated the local authority's potential liability. 2012 was when RICS first announced that Japanese knotweed might be this terrible substance. It doesn't mention the fact that in March of 2022, RICS said it's not the danger we made out to be. Only in exceptional circumstances will it cause structural damage. And the number of claims have gone down and the amount of damages have gone down. But so you can sort of read that Davis and Bridgend reversed.
Well, bang up to date. So thank you for that. Yeah, I mean, I sort of wonder. I mean, these claims are based on stigma attaching to the property, and as you say, RICS rather downplay it a little bit now, so maybe that's a factual assessment to be made on in future claims, I guess. I mean, my own little bit to chip in is we bought a house about 22, 23 years ago. Discovered it had some Japanese knotweed in the garden, and we put some carpet on top of it and left it for 4 years. And when we took the carpet up, it had gone. I mean, it's a very impressive plant, but it's just a plant. It needs light and air and all the rest of it. So anyway.
Oh well, and you can eat it, and you can eat it and drink it. There's Japanese knotweed gin and vodka, apparently.
Live and learn. Well, there you go.
I've got some here for the session.
Right, very good. Okay, well, I think the first of our pre-submitted questions is for you. How do you measure the height of a higher risk building? I didn't know you did, Richard.
This could take the whole hour. I mentioned it in the repair service charge and building safety course, and it's important in commercial property, not just residential. I think a lot of commercial property lawyers have not really cottoned on to how significant the Building Safety Act is for them. And it's important if you're buying the reversion of a block, and it's also important in relation to mixed-use developments and the commercial property side of things, because there's a lot of implied terms in relation to residential units, and they should be there for commercial as well, or express terms should be. But it depends on a higher risk building is basically one that's 18 meters or more in height, or as an alternative, 7 stories. And unfortunately, the way of measuring the height of building for the Building Safety Act, high risk buildings, and also the leaseholder protections, is not the same as in the building regulations. There's got to be at least 2 dwellings to be a high risk building. So again, including mixed use, obviously. And 18 meters is measured from, well, the lowest part of the ground floor, but not the top of the top floor, but to the finished floor of the top floor. And the number of stories, you're supposed to ignore basements. There are alternatives to these, but you're supposed to ignore basements if they're so completely beneath ground level, and any top floor plant and machinery should be ignored. But RICS have been telling their members that you shouldn't be telling people the height of the building, basically, because they think the government's guidance is so terrible. Late last year, RICS produced some new guidance themselves. But I know one thing in life, it's not a lawyer's job to go around measuring the height of buildings. The reason RICS had doubts is because of a case actually last August of last year, I think it was, a tribunal case called Waite and Kadai. So I'll perhaps expand a bit in the notes on it. It was a residential block, not mixed use, but again, important for buying the reversion. And when the surveyors first measured it, they found it was something like 17.53 meters, so it's not a high risk building. Then somebody else measured it, and they found it was 17.97 meters high under the definitions. But then they added a degree of tolerance of 30 centimeters, which just about made it a higher risk building. Then they decided that on the definitions, there was a roof terrace, which was communal for all the flat owners. And that's also a floor. It's not wholly plant and machinery. So it should be measured to the floor of the roof terrace. And that tipped it well over 18 meters. And because of this, RICS basically told their members, we can't have anything to do with this. And it's an almighty mess, as it is with the leaseholder protections, where it's 5 stories or 11 meters in height. I did come across one, for instance. This was about leaseholder protections, 5 stories or 11 meters. It was a 4-story block, and it had a ridged roof, and the ridged roof was boarded out for storage. And for me, that's a 5-story block. It tips over the edge of leaseholder protections. Come across another one. It was a church, and there was a little room in the church spire, quite separately. You measure to that, and probably you do on the guidance. Like a lot of the Building Safety Acts is a mess, Mark.
Yeah. I mean, I just always wonder with these kind of situations, yeah, the owner of the building is, they don't want to spend money unnecessarily, but you kind of think, well, when the building catches fire and people are dying because you haven't complied with Building Safety Act requirements, how good do you feel about arguing about that last 5 centimeters? Shouldn't people sort of take it on the chin a little bit in marginal cases?
I think it's, yeah, I think it's one thing for certain is it's not a lawyer's job to measure the height of buildings. And I would personally, commercial or residential, mixed use, whatever, but selling the reversion, I would make quite clear it's not us. We can't tell you whether it's a higher risk building or a relevant building.
Yeah,
yeah. But somebody else to do that for you.
Yeah, no, I think that's absolutely right. Yeah. Okay. So next question, one for me, and this is about forfeit. Yeah. Can you confirm that it's okay to enforce payment of, say, the June quarter rent by county court proceedings in July without waiving the right to forfeit? Surely at least part of that rent is due for a period after the proceedings are issued. I mean, this is something that very often crops up, and people often don't believe me, unbelievably, when I tell them this. But the waiver of the right to forfeit, there's, if you like, there's 2 time-related tests that have to be met before something amounts to a waiver of the right to forfeit. One is that the act or statement of waiver must be done after the landlord or somebody acting for them acquired the relevant knowledge of the breach of covenant. So that's one. But number 2 is the act must in some way acknowledge the existence of the lease beyond the date when the right to forfeit arose. So, typically right to forfeit arises maybe 2 weeks after the rent falls due. So whatever you do, well, not quite whatever you do, but if you take action to enforce payment of the rent falling due in June, then and you do it in July after the right to forfeit has arisen, it doesn't matter because you're still trying to enforce payment of the rent which fell due before the right to forfeit arose. And the fact that you've got an instalment of rent falling due on 24th of June doesn't tell you anything about the continuation of the lease beyond 8th of July or whenever it is. So it is correct. I know it's kind of counterintuitive because, of course, you're talking about rent which runs through up to September. But of course, as an instalment, it all falls due in one chunk on the 24th of June. And so, as I say, the fact that fell due on the 24th of June tells you nothing about the existence of the lease beyond 8th of July. So yeah, that is right. I mean, the only kind of caveat to it is that it has been held in this case with a virtually unpronounceable name, which I think is possibly Finnish, Tiruna Vuokrazu and Bra. And in that case, the landlord used commercial rent arrears recovery, CRA, after the right to forfeit had arisen to try to recover rent. And the rent fell due prior to the right to forfeit, so it shouldn't have waived the right to forfeit, but it did because when you use CRA, that in itself is an acknowledgement there and then of the landlord and tenant relationship, the existence of the lease. So that's the only kind of caveat to that. But otherwise, yeah, no, that is the correct position. So much for that one. Yeah.
Was there a case called, I think, Dean Plan and Mahmood years back in the 1990s? You remember coming across that?
Yes, I do remember that one. Well, I remember the name.
It was obviously about on levying distress at the time rather than CRA.
Yeah.
But I think that was a similar kind of decision, as I recollect.
Yeah.
It's a long time since I've talked about it. But,
yeah. I mean, that's why, when one looks at forfeiture clauses in leases, they may well give a right to forfeit in the event that distress is levied on the property or CRA is exercised, because exercising it will waive the right to forfeit, but at the same time, on that basis, gives you a new right to forfeit. So it's kind of neat little way of having your cake and eating it.
yeah.
Yeah. Okay. Next question for Richard. Are disclaimers stating that the tenant has not relied on any statement or representation valid? I guess this is the CPSE inquiry's topic.
Yeah. Well, it's a Court of Appeal case from a few years back now, to 2018, I think, confirming the High Court decision. First Tower Trustees and CDS Superstores International in Barnsley. But it was CDS. It was a sort of garden centre DIY store. It's the Range, where they used the CPSE inquiries, and it was the environmental questions, and they put a series of disclaimers down. The landlord, the tenant acknowledges that they have not relied on any statements or representations by the landlord or their agents in entering into the transaction, and a series of statements after all, lots of the inquiries, that the tenant must satisfy themselves. And they failed to disclose the existence of asbestos. They should have known the existence of asbestos. Bizarrely, the tenants were given an asbestos risk assessment that didn't show the existence of asbestos, because they were given an assessment for the wrong property, which takes some doing. And it doesn't all go well for the way the courts are going to treat you. But the tenant finds out about the asbestos, after the lease has been granted. The tenant's now liable. It was going to cost them about £500,000 to remedy the problems with this asbestos, which was in a perilous state. So they basically sued the landlord, and the landlord relied on the disclaimers. It's one of those little known areas, actually. It's Section 3 of the Misrepresentation Act of 1967, which you can read in conjunction with the Unfair Contract Terms Act, and it basically says it's if you're going to exclude or limit liability for misrepresentation, it's got to be reasonable. And the Court of Appeal said that even if they're two large arm's length organisations, CDS are not a small body, it wouldn't be reasonable. And they did go on to say that only an exceptional, it might be reasonable to exclude liability or limit liability in certain circumstances, but they didn't really know what those circumstances might be. It would be exceptional. So if you take that at face value, the disclaimers are unreasonable.
I mean, it is on the face of it a sort of a not very attractive position, is it? So everything we tell you is true, but you can't sue us if we're lying. That's which is effectively what that's about.
Yeah, it is. Well, yeah. I mean, you still see the disclaimers, but I think they're pretty worthless. They didn't actually go on to say that there's a subtle difference between, making a statement and then sort of saying don't rely on this. That's an exclusion of liability. Whereas if you limit your retainer, what you're actually saying, that's not an exclusion of liability, and that's reasonable. That can be reasonable. Rely on your inspection or survey if you can, if the other side's prepared to accept that.
Yeah, it's sort of a little bit like complete agreement clauses, and the entire agreement is contained in this document and nothing else. But I was just thinking, there's a case called Hipwell and Shurek, which I think was about 10 years ago now, which was to do with one of those rare cases where the court implies repair obligations onto a landlord, and the entire agreement clause was one point in the case, and the point being that if you imply a term into a contract, the contract is deemed really to have contained that term from the outset, so the entire agreement clause doesn't stop you doing that, which was sort of a surprising but logical kind of outcome, I think.
I say it is a subtle difference, though, in terms of the inquiry. It's just, if you feel it's an inquiry that lawyers shouldn't be asking and answering, well, the clients shouldn't be asking and answering, to rely on your inspection or survey.
Yeah. Okay. So I've got another one on waiver of the right to forfeit. If the right to forfeit can be waived by any words which acknowledge the existence of the lease, is it safe to refer to your lease, your landlord, etc.? Yes and no, I think, is the answer to that. I mean, it's one of those things that in practice I've always been very careful about, because you don't want to give anybody the argument, give you the stick to beat you with. It means some slightly tortuous drafting of emails and letters sometimes, but it's probably worth the effort. I mean, that said, it's a bit desperate if a tenant's going to rely upon that as a means to say you waived the right to forfeit. And I know there was a case, and I'm struggling to remember the name, but I think it may have been Gibbs and Lakeside Developments a few years ago, where precisely that sort of argument was raised, and the court gave it very short shrift indeed, and said, no, that's just, how else do you conduct correspondence about the matter if you can't use those sorts of expressions? So I think, one, is probably reasonably safe, but on the other hand, why give the other side the argument is the way that I would look at it. But it is, the law of waiver of the right to forfeit is one of the more absurd aspects of a fairly absurd area of law, and that's one of the difficulties that we have with it. So
I think a lot of it is based on pretty antiquated laws, isn't it, really? But
yeah. I mean, there's a quotation from the Law Commission, I think, which is that it's archaic, it's uncertain, and it can lead to injustice. All of which is quite true. So as and when the government, or a government, whatever government, at some point decides to pick up the Law Commission's reform proposals, which date back now 30 years to 1994, that would be great, because then I wouldn't be able to do 3-hour trading sessions on forfeiture anymore. It'd take about 5 minutes. But there we go.
yeah, I suppose the other thing is that a lot of landlords are desperate to keep the tenants regardless at the moment.
Yeah, that's right. I mean, I think as we sort of came out of the financial crisis, 2008, etc., and people got a bit more confidence, suddenly there were a little flurry of forfeiture cases in the law reports, but the pandemic did for that, really. So no, it's not the most popularly used remedy these days.
I think it's also, business rates liability on empty properties is
yeah
a great concern, isn't it?
Yeah, absolutely.
I've come across situations where tenants have just up and left and done a runner, not paid the rent for a year and not been seen, and the landlords, well, they won't re-enter because they can then argue to the local authority, go and find the tenant and he can pay the business rates.
Sure. Yeah.
It's a sign of the times.
Yes, indeed.
But it's like you say, that if the Law Commission proposals and commercial leases were taken up, I think we'd both be out of a job. If they get rid of the 54 Act as well.
Yes, that would be a earth-shattering sort of move. I don't suppose the Law Commission's consideration of that later this year is going to be quite that dramatic, but we'll see.
They keep putting it back, don't they?
Yeah. Anyway, next question. One for you again, I think, on CPSEs. Can not known give rise to a misrepresentation?
Yeah, well, the answer is bizarrely yes, because a lot of people think that's what you should be basically doing. There was a residential case. I suppose going back in time to a development land case, which was a bit of a cause célèbre at its time, was Sindel in Cambridgeshire, which was about, are there any sewers under the land we're about to, local authority was selling with planning permission for 30 odd houses. And Sindel sort of, raises inquiries, are there any sewers? And the response came back, we're not aware of any. And the worst sewers, they were found to be, on the flimsiest of grounds, actually private sewers, not public adopted sewers. But at a later stage, Sindel wanted to rescind the contract, primarily because the market had turned for the worst in the meantime. And so they argued misrepresentation. And amongst other things, the court decided that not aware is a representation you've taken all reasonable steps to find out. And as it happens, they decided you couldn't rescind the contract. The breach was too insignificant and you'd taken reasonable steps to find out. But yeah, there was a residential case called Rosser and Pacifico, which was in the notes last year, where it was a house in a conservation area in Cardiff, which was being converted by Pacifico into two flats, and one of these flats was being bought by Rosser. It was advertised as a 2-bedroom flat, and they asked the question about planning permission. You got similar questions in the CPSEs about planning permission and building regs breaches, and the answer came back, we're not aware of any. And cut a long story short, there were planning breaches because it was in a conservation area and there's an Article 4 direction. You're not supposed to see the windows without planning permission from the highway. And there was a Velux window, and they had to take it out. And by taking the Velux window out, it's not a bedroom. It needs natural lighting and ventilation. And so they were sued for claiming it was a two-bedroom flat when it was a one-bedroom flat. And the court said that not aware is a representation. It's in Section 2 of the Misrepresentation Act. It's actually a tort. It's not a contractual claim, but which basically says that you can claim damages against somebody. There's no suggestion of fraud. You can claim damages against somebody, even if they've made a representation that's not fraudulent, unless they either knew or had reasonable grounds to know that the representation was wrong, and the court decided they should have known that the representation was wrong. Not known was a misrepresentation.
I mean, just out of interest, what if you replied, "We have made no inquiries or investigations, and we are not aware of any"?
I always suggest in courses, if you can't say not known or not aware or don't know, I always thought don't care is another possibility. some of the inquiries you get, you must have been tempted to do that. People sometimes. But I think that's something for your last week at work, honestly. I think that it is that not known, but no investigations have been made. And that, going back to the previous question I was asked, that's not an exclusion of liability. That's just limiting your retainer. That's limiting what you've done. And the only question is whether the other side accepts that.
Sure. Yeah, I mean, I was thinking, when people take leases of property, and they make their pre-lease inquiries, and they very often accept those sorts of answers. And really, landlords ought to have an idea about the physical condition of the property, don't they?
Well, that's
if you can push back a bit further on those things, maybe you can achieve something useful.
Well, that's what they said in Oscar and Pacifico. Pacifico was a small development company solely owned by some Hughes Jones, almost Jones Hughes or something like that, who is in Australia, so he left other people to do all the work. And the court, as I say, decided he wasn't in any way fraudulent. He genuinely didn't know, but it's a representation. You've taken reasonable steps to find out. There was a case that people do in their degree level studies called the Nottingham Patent Brick Company in Butler back in the 1880s. Do you remember that one, Mark?
No, that's a long time ago. I mean, not 1880 is a long time ago, but so was my student days. I don't remember that one. No.
It's one of those you conveniently forget as soon as you can, where they ask questions: are there any restrictive covenants in relation to this land that we're buying? Because if there are, we can't develop it. And the answer came back not aware of any, and that was a representation you've taken reasonable steps to find out as well. It goes back to the 1880s.
Going. Well.
I think you should. I mean, they also said in Rossa that you can't pass the buck on to the buyers, if you like, because the sellers are the ones, like you mentioned, who should be in a position to know.
Yeah. Interesting. Okay, thank you for that. And another one for me, still on forfeiture. Methods of forfeiture this time. Can peaceable re-entry be justified in a modern legal system? I'd have thought it would almost inevitably cause confrontation. I think, since the Human Rights Act was passed, there have been concerns about distress, which led ultimately to distress being replaced by CRA, and concerns about peaceful re-entry. But there has not, to my knowledge, been any successful challenge on a human rights basis to peaceful re-entry. I think some landlords who are particularly sensitive to PR issues, might be local authorities, whatever, they just won't use it because it has that sort of image to it. And one thinks of three big lads jumping out of a van and starting to drill the locks out, and it all sounds very, very sort of confrontational and draconian. I think it was in Bilton and Residential Apartments in 1992. The House of Lords said it was a sure recipe for violence, and I have to say that not that I've ever attended a peaceable re-entry, but that is not my experience of how clients have dealt with it. I mean, I think the clue's in the name, peaceable re-entry. You have two important restrictions to be aware of. One is you should never do it in relation to residential property, or any part of the property is residential. It's a criminal offence. And the other criminal offence is if force, or the access violence in the Criminal Law Act 1977, if violence is used against the person or property in order to gain entry, and there's a person, doesn't have to be the tenant, anyone, a person present in the premises who's opposed to the landlord recovering possession. All of which means, in practice, the bailiffs go along. If there's somebody there standing in the doorway saying no, they turn around and walk away. So it rarely leads to any sort of problem of that kind. I mean, you can see, obviously, there is potential for confrontation. If bailiffs go into a property, and they tend to go in, of course, for this reason. They tend to go in the early hours of the morning, or in the evening, or on a weekend or a bank holiday when they expect there's nobody going to be there. But if a bailiff goes in and changes the locks, and they start at 5 in the morning, and they're still there when the businessman turns up whistling a happy tune, expecting to start his day's work at 8:30, there may well be confrontation. But by and large, it doesn't result in a problem. I had a delegate on a course once when I was talking about this, and he was a surveyor, and he said when he was a young Turk, and he first got involved in a situation where a lease was being forfeited by peaceable re-entry, and he thought he'd go along and see what it looked like and see what happened. And he spent the next couple of days in A&E with a nasty headache as things had kicked off somewhat. So anecdotally, sometimes it happens, but it is. I'm trying to think. I can't think what case it was. Dear old Lord Denning, in some case, said it was a remedy of undoubted legality, and indeed it is. So there it is. But yeah, I mean, I think if the again, if the Law Commission's reforms are passed, then peaceable re-entry essentially will be a thing of the past as well. Whether you think that's a good idea or not, I mean, I was thinking again, if you've got a breach of covenant which is absolutely straightforward, there's no justification, something that can easily be dealt with by the tenant, peaceable re-entry is the way to go. Because it costs very little compared with paying expensive people like me and Richard to go to court for you, and is an awful lot quicker, and it's very effective. And I've had conveyancing colleagues say to me, "Oh, we were trying to persuade this guy to pay his arrears for 2.5 years, and he kept paying a bit and then getting into arrears again, and always behind to some extent. And the client lost patience and sent the bailiffs, and he came up with all the money. What a surprise! I mean, it is, as they say, the ultimate security for payment of rent. But like distress for rent, if it goes, some of us may mourn its passing, but it's not very much in keeping with the spirit of the times, I don't suppose.
I mean, like you say, I have seen situations where, well, I came across one actually, but anecdotal, where the tenant hadn't been paying the rent. They thought the property was empty, and they peaceably re-entered, or so they thought. It was dead of night, to find that there was loads of people working there. They opposed their entry. You breached Section 6 of the Criminal Law Act.
Yeah.
So it does happen. And as you mentioned at the beginning, biography, I do quite, over the years, I've done a lot with local authorities, and I'd always advise local authorities, you can do this, but do you want to do this because of the publicity involved and the likes? You'll get the councillors onto you if you start doing those kind of things. And again, I've seen examples of people who won't peaceably re-enter. Eventually, you're going to have to peaceably re-enter. But you might find it difficult to find another tenant for the premises, certainly for 6 months, because, just in case they kind of claim relief on the remote chance.
Absolutely, yeah. I remember a situation before the House of Lords reached their decision in Bilton and residential apartments, and for a time it was thought to be the case that you couldn't apply for relief following a peaceable re-entry. And I was acting for a lender who lent about £17 million on a property in the City of London, and the tenant, the borrower, had become insolvent, and a Section 146 notice had been served. And we were lucky because in that case, the landlord took the trouble to send us a copy of the Section 146 notice, which they're not obliged to. And we said to the client, well, put a 24-hour security presence in and don't let anybody in, and then they can't, they can't change the locks. What actually happened was the bailiff turned up at sort of 5 in the morning. Security guard said you can't come in, and the bailiff said, well, we've been sent to by the landlord, and the security guard said, oh, I suppose that's probably all right then, and let them, let them in.
He's not a very good security guard.
So until the House of Lords decision, yeah, that was the end of a £17 million security. But anyway, there it is.
Yeah,
we should resist the temptation to just trot out anecdotes, shouldn't we? Really, but there it is.
Not non-payment of rent, but I've seen tenants in the financial crisis, and back in 2008-9, deliberately trying to wind landlords up. The landlord would fall for it and bring forfeiture proceedings.
Yeah.
There was a case involving, it was B&Q and GS Fashions, where they served a Section 146 notice and started forfeiture proceedings and went off to court. But unlike most forfeiture proceedings, the tenant was claiming the lease had been forfeited and the landlord was seeking forfeiture. And the tenant, well, if you choose not to defend the proceedings, then your obligations is the break clause you never wanted to negotiate.
Yeah. Okay. Move on, and again, one for you on CPSEs. Should the solicitor check the client's responses are correct? That sounds like rather an onerous sort of.
Again, believe it or not, I mean, this
duty.
this is one of those areas that, sort of, it doesn't matter whether it's residential or commercial. The law is pretty much the same thing. It's just the question. There's certainly cases where the buyer's solicitors should be checking the seller's responses are correct. There's a case called Cooper and Stevenson back in the 1850s that said that. And Sindel was in-house lawyers with the local authority, Cambridgeshire County Council. But there was a suggestion that you might just be liable as certainly subject to a sort of reasonableness test. If the seller's telling a pack of lies, you might just be liable as a seller's solicitor if you don't draw attention to that fact. I think if they were telling a pack of lies, you'd have to question whether you wanted to act in circumstances. But it's quite possible. It's a reasonableness test. It's not an absolute duty. And the inquiries make clear that it's the seller's responses. It's not the solicitor's response to the inquiries. But if you should believe that something's untoward, certainly the buyer's solicitor should still be checking.
Yeah, so I mean, there would have to be, I suppose, a sort of threshold that would put you on inquiry. There's something fishy, or it seemed a very improbable response, something of that sort.
I mean, the Sindel case seemed to allude to, it was actually in the residential inquiries at the time, that you should look at previous files relating to that. If you acted on that property in the past or whatever. But incredibly onerous. As it happened in Sindel, I mean, it was unregistered land, and part of the deeds have become dislodged from the rest. And if they'd have ploughed through the vaults at County Hall, they'd have found that back in the 1950s, I think it was, sewers have been laid under this land. But the court decided you've acted reasonably. You can't be expected to, go ploughing through all your vaults in these circumstances. So it is a reasonableness test.
Yeah. I mean, how can you do conveyancing work profitably if you're going to have to carry out those sorts of investigations?
Well, that's the other thing you might consider doing, is that not just no investigations have been made, but we haven't looked at previous files and the likes.
Yeah.
But where do you draw the line? You just have a disclaimer, then report, really.
Yeah. I suppose whatever you say, there's always the risk at some point the judge is going to say, well, you can't just wash your hands of it like that.
Yeah. In which case, the best thing is to say nothing, or say nothing in a roundabout way so they don't realise you're saying nothing. No, I think it's no investigations have been made.
Yeah. Okay. I have another one on forfeiture. I think it's maybe the last one on forfeiture. And it comes back to a comment you made this one. It says, if a potential new tenant following a forfeiture is told there is a risk of an application for relief, won't they just walk away from the deal? I think that picks up on something from my session where I was saying that you have this risk of an application for relief up to 6 months, in some cases longer, after the forfeiture has taken effect. I mean, there are time limits which have been put in place in a sort of slightly piecemeal and not very consistent and unsatisfactory way for about what's it, good 150 years from the Common Law Procedure Act, probably like 170 years. And
1852, wasn't it?
1852, yeah, so it's about 170 years. That is designed to limit the risk and make it possible for landlords to relet property without having the threat of an application for relief hanging over them forever. But it's still quite a long wait. And, I think things you can do, I mean, this is best thing you can do is get a declaration from the court that there will be no grant of relief, which if everybody has been notified of the forfeiture and told, we are making an application for a declaration, and if the court's satisfied with that, then why shouldn't there be a declaration? That takes time, so that may not always be possible. Next best, I think, is contacting all the potential applicants for relief and saying, we are going to grant a new lease. We're going to give you 2 weeks, a month, whatever, to make an application for relief, and then we'll grant the new lease. And that's clearly going to go against them if they then make an application for relief after that period of time. It being an equitable jurisdiction. But yeah, probably the least favourite, but it is one way of dealing with it, is to say to the incoming tenant, the property is being let because there's been a forfeiture, and it's possible that there will be an application for relief, and it transfers the risk to the incoming tenant. And there are two difficulties with that. One is that you have then successfully made them not equities darling. So that they have notice of the potential of an application for relief. If an application is made, that again makes it more likely there will be a grant of relief in some form. Whereas if they're equities darling, that it becomes much more difficult. But the other drawback is exactly what's identified by the question, that the incoming tenant may say, well, in that case, I'm not too happy about that. I'm going to go and find some other premises. So I think one has to decide what is the best way of protecting against the potential application for relief. It is one way of doing it, but it certainly has its drawbacks. Yeah.
Would the courts, if relief did, there was an application, would they take into account the fact that third parties are going to be affected? You've now got another tenant.
Yeah, and there was a case of Fuller and Judy Properties a few years ago. And what the court did rather neatly was grant relief in the form of an overriding lease to the applicant. So the new tenant, who was equities darling, they didn't have notice of the risk of an application for relief, didn't lose possession. They didn't get kicked out. So that's great from the landlord's point of view. It means no claim for derogation from grant. As regards the applicant for relief, well, of course, they received the benefit of the rental income from the new tenant, and in turn had to pay rent under the old reinstated lease up to the landlord, which could be a Pyrrhic victory, or on the other hand, if there's a profit element in the sub-rent, it's still worth having, So it is quite a neat solution, and I think that's probably what you would expect a court to be looking at doing in the modern law.
Mm.
Okay, and another one for you. What is the effect of not having a fire safety risk assessment?
Yeah, this was in the CPSE inquiries
yeah.
as well, because I think it's inquiry 11. And you've been the regulatory reform fire safety order 2005 came into force in October 2006, and the CPSEs changed before that, and they haven't changed since. And I think they probably should. That's one thing I'd say. If you don't have a fire safety risk assessment, the person who's in control of the premises is breaking the criminal law, the maximum 2 years prison and unlimited fine. but also quite separate. It doesn't say this in the legislation, but for years upon years, I've come across insurers saying that if you didn't have a fire safety risk assessment when you should, and you didn't implement it as the other thing, then I remember talking to Aviva about it when they were still Norwich Union, that dates it, and being told that, I think the words they used were, we would reserve the right to refuse reinstatement after fire and public liability. So your insurance is up for grabs. I have come across one situation where they'd had a fire safety risk assessment, but not fully implemented it. So most of the high street haven't even had these things, you know. But a large majority of the high street, well, they'd had a fire safety risk assessment, not fully implemented it, and there was a fire, and the fire was, you know, well, basically the insurer did refuse the claim.
Wow.
It was a fish and chip shop, Mark. So that's true. But
yeah,
sort of probably affected it a little bit. But I think your insurance is the real worry.
Sorry,
I was going to say, I think landlords should, because once the tenant's in occupation, the tenant's in control, the tenant should have a risk assessment, and the landlord should have them for any common parts. I think the landlords, I mean, what do you do if the tenant doesn't have a fire safety risk assessment and there is a fire? Well, the lease will probably say, almost certainly say that the tenants, doesn't have to reinstate after fire, the rent's suspended for X amount of time. Then it will say except to the extent the insurance is vitiated by the acts or neglect of the tenant. Or there will be people claiming under them. So the tenants, will still have to pay the rent for a property that's gutted out and reinstate it at their own expense. It mentions that repairing course I did. But a case called Matthew and Curling in 1924. But in the real world, if it's a high street tenant, they're just going to go bust.
Yeah.
And they're not going to be worth suing, quite honestly.
Sure.
And the landlords lost their property, and I think landlords need to be more proactive about making sure tenants do have fire safety risk assessments.
I mean, it's interesting that the consequences obviously go beyond the statutory scheme, to insurance. And I was just thinking that there's a case just in the last year about a landlord trying to recover the cost of a waking watch through the service charge provision. Ratcliffe Properties in Meeson, or am I making that up? Something like that. And they're looking to recover about £58,000. And what had happened was the property had been converted to flats a couple of years previously. There'd been a fire risk safety assessment with a number of recommendations for actions to be carried out. The landlord hadn't bothered, and the property owner, I should say, hadn't bothered, yes, the landlord, and then there was some water ingress which caused a fault in the fire control panel. So of course the fire service then got involved and raised all the issues raised by the fire safety risk assessment. Said, look, you've got to get all this stuff sorted out. You've got to put a waking watch in place until it's all dealt with. They put the waking watch in place, cost them about £58,000. When they tried to recover that through the service charge, all but 7 days of that was held to be unreasonable. The 7 days being the time taken to deal with the damage to the fire control panel, because everything else was down to the landlord's failure to act on the fire safety risk assessment. So that's another impact beyond just non-compliance with the statutory scheme. So yeah, I mean, I agree. Landlords, I mean, you would think people would take fire safety seriously, wouldn't you? But yeah.
Oh, it's amazing that in the world of residential, where you need them for the common parts, a bit of a question mark over that since the Fire Safety Act of 2021, whether it applies to the whole building. But the vast majority of residential blocks have had fire safety risk assessments. Whether they've implemented them is another matter. And the high street are not the big time players. I'd be amazed if it's close to 20% of high street tenants have had risk assessments. And I suppose the other thing is, before you've got CPSE inquiries make this quite clear. Please advise where we might inspect the risk assessment. And before the lease is granted, if the landlord, the landlord's the one in control of the vacant property, or the future landlord, And that CPSE inquiry, you'll get a standard response from large numbers of people, including larger premises. Get your own done when you move in. You might have to get your own done when you move in because your needs are different, than the landlord's. But if the future landlord hasn't had a risk assessment and implemented it, they're probably vitiating their insurance.
Yeah, yeah.
Or commercial freehold for that matter.
Indeed. Okay. So next question is on to opposed lease renewal. So one for me, can you confirm that ground C doesn't necessarily require there to be any breach of covenant? And indeed, I'm happy to confirm that. And there's been, I think there's been about 4 cases in the past 10 years or so on the tenant default grounds A to C under Section 30, subsection 1 of the 1954 Act, which have given us some sort of useful clarity on how these paragraphs operate. And ground C is kind of the interesting one. Ground A is disrepair, ground B is arrears of rent, or persistent late payment of rent, I should say. And ground C is the interesting one, is other substantial breaches of covenant or any other reason connected with the tenant's use of the holding. The case that is kind of most striking on this, it was a case back in 2014, Horn and Meredith Properties in Cox. This was to do with a shop in Bridgnorth in Shropshire, which, charming old market town. Like charming old market towns, it has a very difficult street pattern and lots of pressure on parking and so forth. And Mr. Cox and his partner were tenants of this shop on a 15-year lease, and they had a right to 2 access ways and 5 car parking spaces under the lease. And Mr. Cox, unfortunately for the landlord, turned out to be a vexatious litigant who had a bee in his bonnet about the parking and the access, and litigated for 16 years, costing 500,000 on each side, and no breach of covenant at all. When that came to the lease renewal, understandably, Horn and Meredith Properties were kind of on their knees begging the court, don't please make us have another lease with Mr. Cox. And Mr. Cox, under cross-examination with admirable candour, said, if I get a new lease, yes, of course, I'll continue my programme of litigation. And so the court decided that it was unfair to foist Mr. Cox onto Horn and Meredith Properties as tenant for a further term. So ground C was made out. So no breach of covenant, just any other reason connected with the tenant's use of the holding. It's really very broad indeed, and the cases show that you can look at everything in the landlord and tenant relationship. You look at the overall picture. Is the relationship between landlord and tenant such that no new lease ought to be granted? What's called the ought not test. There's another case in the same year as the Horn and Meredith case called Yosefi, where there were allegations of each of the 3 grounds being made out: disrepair, persistent late payment of rent, other substantial breaches, and the court rejected the ground A and ground B and just went on ground C. But in answering that ought not test, they regarded themselves as being able to look at all the matters that were raised in relation to ground A and ground B, even though they weren't in themselves sufficient to justify the refusal of the grant for a new lease. So yeah, it's a very broad ground of opposition indeed. Sorry?
I'm having a coughing fit, so.
Oh dear, bad luck.
Nothing to add.
Right, okay. Well, we'll give you a second to get over your coughing fit, but well, I'll go on to the next question for me while you're getting over your coughing fit. Is it possible to clarify further what works qualify under ground F? The position seems to be a little confused. And it is, yeah. So landlord's intention to demolish, redevelop, carry out substantial works of construction on the holding or part thereof. Lots and lots of cases where the courts have had to decide, do the works qualify? And there's obvious cases, if the landlord's going to put a bulldozer through it, well, then that's demolition, end of story. But if you're looking at something else, then there's a range of different possibilities, just going down to rewiring in a lick of paint, you get, as I said in the session, there's conflicting statements from the cases about whether you need any structural element in the work, and the case of Pumpernicks and of Piccadilly and Land Securities, it was a sort of unusual outlying case where it was an eggshell tenancy, so all that was demised to the tenant was paint and plaster, essentially. And when the landlord opposed renewal of the lease on ground F, the tenant said, well, nothing you intend to do can affect the structure, or nothing you intend to do to our demise can affect the structure, because no part of the structure is let to us, and therefore nothing you can ever propose to do will engage ground F. Good try, but the court said, well, this is essentially demolition, because every physical part of the building which is let to you is going to be obliterated by the work, and therefore it qualifies under ground F. So I think apart from unusual cases like that of an eggshell tenancy, my sort of dividing line would be there must be some work on some structural part of the property in order to qualify under ground F. But the cases are not entirely clear, and I think again, in one of the cases the judge said it is a jury question. So how much does the file weigh, finger in the air, which way is the wind blowing? It's a bit of a judgment call on that one. I don't know, anything to add if you're recovered?
Yeah, I'm better now. But, I was going to say, Mr. Cox, I bet he went down well in court. Meredith Cox. I remember that case. It was just absolutely amazing. But yeah, that was that recent Sainsbury's case.
Oh yeah.
Medley assets.
Yeah.
Which was all about sort of, not particularly reconcilable with other cases, but where they were, well, it was decided on different grounds, but strange grounds that you can just vacate the premises or but a little part of the premises. Then you can argue that the landlord doesn't intend to demolish, reconstruct the holding because I wasn't in occupation or anything. And then, you get your renewed lease, and then you go back into the whole of the premises and get a renewal of the whole.
Yeah.
But they did talk about they were putting digging the basement downwards, making the basement sort of bigger, and they basically said that the basement, underneath the basement wasn't let out to the tenant, therefore the ground F doesn't apply. They also dealt with other cases like Atkinson and Bettison and the likes. It's really a question of degree, but I've seen cases on ground F, and without the benefit of hindsight, you won't be able to tell whether it's intention to demolish or reconstruct or not.
Yeah. No, that's right. It's. I think it's probably nothing more to say on the specific question. I mean, just to say, as you mentioned it, that Sainsbury's and Medley Assets case. I think it's very unattractive, the idea a tenant can move out of an area purely because the landlord has specified ground F in order to defeat ground F, and then go back in and then get a new tenancy, including that area. And it seems to me to be precisely the kind of thing that the Supreme Court was disapproving of in the Francis and Cavendish Hotel case. Although the tenant's intention in moving out of a property, moving out part of the property, isn't relevant for establishing ground F, but it does occur to me that you look at cases like Bakayaki and Academic Agency. There's a few cases where a tenant has been held to be in occupation despite being physically absent, and that's the kind of concept I thought could really have been used to defeat this kind of wizard wheeze of Sainsbury's in that particular case. I mean, we'll see if there's an appeal. We'll see if anybody tries this again and what happens to them. But it does seem a rather unattractive kind of outcome to me, though.
I've been to the very restaurant, Bakayaki, in Bath, to North Parade.
Yeah.
Used to live close to there. Thought I'd had to.
Very good. Well, I hope they treated you well.
Used to be Italian. It's now Greek.
Yeah. Bakayaki, I think, is a Corsican name, if I'm not mistaken. Anyway, fascinating though that may be. The next question is one for you. back on fire. I mean, have you already answered this? Does the landlord have to give the tenant a fire safety risk assessment in line with the CPSE
I
inquiries?
think it probably does. I've answered that before, sort of that, when the property is vacant, it does say in the CPSEs, please advise where we may inspect the risk assessment.
Yeah.
And the landlord should be given it's not I mean, even if the tenant has to do their own risk assessment when they move in, it's not a bad idea. Just like even more so with asbestos risk assessments, because it'll give you an idea as to how much you might have to spend.
Sure. Sure.
I think it's classic, it's not fire safety, but it is asbestos in certainly pre-2000 builds. Because I'd want to see the landlord's asbestos risk assessment. And if the place is ridden with asbestos and it's in a perilous state, I don't think I'd take on the lease in the first place.
Yeah. Yeah. I think we have time for one more question, which is one for you, and certainly one well worth a natter about. After Sarah and Hussein and Blacks, should tenants attempt to change service charge on a lease renewal?
Yeah, Sarah and Hussein, Supreme Court case from early last year, added to the Court of Appeal and High Court decisions. This is a place I know as well, actually. Chicago Buildings in the middle of Liverpool.
Right.
The landlord basically, the tenant had to pay the service charge. And the certificate was held to be, deemed to be conclusive in the absence of fraud, manifest error, or mathematical error. And the Court of Appeal said that that means what it says. You can't question the reasonableness of the service charge. The Supreme Court decided that that is the case. So the landlord is guaranteed his service charge and he's got a cash flow. But if you didn't like that and you thought it was wrong, you'd go back to court for a separate case. Most high street tenants are not going to be able to go to court, to argue that case. So you're more bound by the service charge. And I think service charges should have some sort of, certainly reasonableness test. It's implied in residential leases under the 85 Landlord and Tenant Act. There's no statutory provisions for commercial, and they should be based on floor area and sort of, and caps on service charges and all these kind of things. I think it's very important in going forward in terms of landlords carrying out works in relation to energy efficiency and adding the cost to the tenants via service charge. The question on a lease renewal, though, I don't know if you touched upon this. I mean,
No.
The question on lease renewal is, well, Section 35, the 54 Landlord and Tenant Act says that you're supposed to have regard to the terms of the current tenancy on a renewal. And O'May and City of London Real Property Company said there's a strong burden on the person wishing to change the terms. Somebody actually was asking me about this in a course not so long ago. So I mean, the starting point is that I don't know what you think about it, Mark, but you'd have to fully justify why that should be changed from the original term on a renewal, in the 54 Act renewal, unless the parties obviously agree.
Yeah, absolutely. I mean, I also find this quite difficult. I mean, there's because it's also wishy-washy, really. Section 35. It says the court must have regard to the terms of the old lease, and it's become quite a rigid sort of principle, really. And I think of a case that I had some years ago where our client had a new landlord, insurance company had bought the development, and it came to renewal. They said, here is our new modern form of lease which you're going to sign. And our guys were on a lease which dated back about 35 years and looked a bit archaic. And our guys said, no, thank you very much. We're happy with what we've got. And both sides dug their heels in. And we ended up about a week and a half before trial with an enormous kind of Scotch schedule of disputed terms on the proposed new lease. And tens of thousands of pounds spent on each side. And about a week and a half before trial, the landlord caved because they knew that we would get away with exactly what we'd started off with. And people always say you're allowed reasonable updating. To my knowledge, that expression has never passed a judge's lips in any decided case on this. It's a kind of convenient market consensus, I think, where the scope of that isn't very clear. But I agree. I think it would be very difficult to change that provision in a service charge. And I think I mean, in the particular case, the service charge went up, if I remember correctly, from £50,000 in 1 year to £400,000 the next. I mean, it went up by 8 times. for tenants who don't need that kind of hassle and don't want to get involved in litigation trying to overturn things, then I think it's important enough really on a lease renewal to say, well, don't care what the outcome of being court, we ain't going to sign a new lease on that basis. We'll walk away and find other premises if you ain't going to. I mean, it's in the service charge code. As you say, there's no legislation for commercial service charge, but there is the service charge code, now an RICS professional standard, which provides that tenants must have the opportunity to challenge the service charge. It's I think it's a result which I can understand in terms of the interpretation of the lease, but it's a very poor outcome, and I think tenants need to negotiate better terms in their service charges.
Yeah, definitely to deal with energy efficiency measures and so on in the future, because the landlord will go to town. The tenant's only got, how I say it's an excluded lease, and you're into the last couple of years of your excluded lease, there's only one winner, and that's the landlord.
Yeah.
But yeah, the upgrading to modern standards is surveyor talk, really.
Yeah.
Most surveyors I've talked to think you can do that, and no, you can't.
Yeah. Well, on that stirring note, I think we've come to the end of our allotted time. As I mentioned at the beginning, a recording of today's live Q&A will be sent out by email within the next few days. There's still time to watch the pre-recorded content. Your expiry date will be displayed next to the webinar, and there's still time to buy the complete event, including a recording of this live session if you haven't already. And you can do that at www.thesolicitorsgroup.co.uk, where you'll also find the online exhibition. That's open for anyone to visit. And if you've booked the entire event, you can claim your free 1-hour CPD webinar from the webinar learning catalogue, and that's worth £35 plus VAT. Finally, feedback forms for the event will be sent out when the event closes. By completing this, you'll receive your CPD certificate. So thank you for watching, and thank you, Richard, for co-presenting. A pleasure as always.
Thanks, Mark, and thanks everybody else.